Will justice finally be served for former Prime Minister Dr Manmohan Singh? Will justice finally be served for former Prime Minister Dr Manmohan Singh? Former PM Dr Manmohan Singh cleared in coal block allocation case after over a decade of legal battles. Dr Manmohan Singh served as Prime Minister from 2004 to 2014. The CBI filed two closure reports in August and October 2014, concluding there was insufficient evidence to prosecute Dr. Singh. In March 2015, the special CBI judge rejected these reports, holding that a prima facie case existed. The trial court's order contained adverse observations that had remained against the former Prime Minister for more than 11 years. New Delhi, the Supreme Court of India has formally brought an end to over a decade of legal proceedings against the late former Prime Minister Dr. Manmohan Singh in the Talabira-II coal block allocation case. A three-judge bench set aside a 2015 order of the Special CBI Court that had rejected the investigating agency's closure reports and summoned Dr. Singh as an accused. The bench held that there was no cogent reason or compelling basis for the trial court to reject the findings of the Central Bureau of Investigation, CBI, and proceed with criminal prosecution. The legal proceedings originated from the 2005 allocation of the Talabira-II coal block in Odisha to Hindalco Industries, a flagship company of the Aditya Birla Group. At the time, Dr. Singh held the Union Coal portfolio in addition to serving as Prime Minister. The CBI investigation examined whether the change in allocation, allegedly made contrary to the initial recommendations of the screening committee in favor of a private entity alongside public sector undertakings, involved criminal conspiracy, criminal breach of trust, or the abuse of official position. Following a comprehensive investigation, the CBI filed two separate closure reports in August and October 2014, concluding that there was insufficient evidence to prosecute Dr. Singh. However, in March 2015, Special CBI Judge Bharat Parashar rejected these reports, holding that a prima facie case existed. The trial court took cognizance of alleged offences under sections 120-B, criminal conspiracy, and 409, criminal breach of trust, of the Indian Penal Code, along with provisions of the Prevention of Corruption Act. Dr. Singh immediately challenged the summoning order before the Supreme Court, contending that the allocation of the coal block was a bona fide administrative decision taken within the prevailing policy framework and involved no criminality. On 1 April 2015, the Apex Court stayed the summons and all consequential proceedings, granting him interim protection that remained in force for the rest of his life. During the final hearing, Senior Advocate Kapil Sibal, appearing for Dr. Singh's legal ace, requested the court to expunge the adverse observations recorded by the trial court. Sibal argued that the special judge had effectively imposed vicarious criminal liability on the former Prime Minister despite the CBI having twice concluded that there was no evidence of wrongdoing. Senior Advocate Abhishek Manu Singhavi also urged the court to remove the findings against Dr. Singh in light of his passing. The Supreme Court expressed concern that the trial court had rejected the investigating agency's conclusions without adequate legal justification. The bench emphasized that settled legal principles governing the acceptance or rejection of investigation reports must be followed and held that, in this case, the special judge had exceeded their jurisdiction. Is it fair to hold former Prime Minister Dr. Manmohan Singh accountable for the allocation of a coal block over a decade ago? Tell us in the comments yes or no.
Here's what this means for you. Always scrutinize the evidence presented by investigating agencies before accepting or rejecting their findings. Save this video for future reference.
Follow Legal Output on Instagram and Legal Output Official on YouTube for daily legal updates.